Hello, good afternoon if you're on the East Coast, and good morning if you're way out west. I know we have a few listeners out in Hawaii and elsewhere. You are listening to Ed's Prohibition on Incentive Compensation, which is a higher education webinar, part of Thompson Coburn's higher education webinar series, and we're certainly glad you're here. I'll go ahead and get started with housekeeping. As always, you'll see here on our platform there are some widgets, as we call them, down at the bottom of the screen. I'll take questions at the end. This is a 90-minute webinar. I'm going to try to leave time before we get to the 90-minute mark, of course, to start fielding those questions. You can put them in the chat box, and then we'll get to them there at the end of the presentation. If you do have questions during the webcast, though, you don't have to hold them. You can submit them in real time through the Q&A widget there at the bottom of your screen. A copy of today's slide deck is available in the resource widget. Certainly you're welcome to download that. In fact, we hope you will. You'll notice that throughout the presentation there are links, and that is by design, and you can click on those links. They're active, and there are a number of resources embedded in the presentation that you'll be able to get to on the World Wide Web. And if for some reason you can't get a copy of that presentation, you have an issue, you can always email us, of course, and we'll send you one. You can also find answers to some common technical questions down there in the help widget at the bottom of the screen. For the lawyers on the line, this webinar, like most of our webinars, 99%, is CLE accredited. In this case, in California and Illinois for an hour and a half, a general CLE credit, and in Missouri for 1.8 hours of general CLE credit. 1.5 hours of general CLE in Texas is pending. Keep in mind we award CLE based on attendance for the entire 90 minutes. So from the time to time, you will be required to click a little pop-up screen just to indicate your continuing engagement. And then finally, as always, there is a survey at the end of this webinar. We are extremely grateful for the folks who take the time to fill that survey out. We do always try to make the next one better than the one before, and we do read all of those comments. So I mentioned earlier, this is part of a higher ed webinar series offered by Thompson Coburn. I am an attorney here at Thompson Coburn. My name is Aaron Lacey. We're a full-service law firm. I have these days, I think, about 400 attorneys, offices in places like Chicago, Los Angeles, St. Louis, Dallas, and D.C. I am physically located in the middle of it all here in St. Louis, Missouri. And I'm the chair of our higher education practice, which provides legal counsel, compliance, training services, all kinds of things to colleges and universities. Here's a nice little picture graphic of some of the smiling faces, the folks in our higher ed practice. Our webinar series typically runs fall to spring of each year, and we try to do about 4 in the fall and about 4 in the spring, tracking the academic calendar. This year, you'll notice on our chart, we disappeared in March and April, and candidly, we've just been really busy. I'm sure like a lot of you all as well, but we are going to try to make up for it. We've got today's on incentive compensation, and then in June, we're going to do on important court decisions and student disputes. And those of you who listen in regularly know, typically sort of middle of the year, I will try to do what I'll call a regulatory roundup. And just look at what the department may be thinking, if there have been any announcements, those kinds of things, new regulations that have recently become effective or may be becoming effective soon. I will say right now we're in a little bit of a lull just insofar as I think the current administration is there's a lot happening behind closed doors, and I think that they are making lots of plans for significant regulatory activity over the next 2, 3, 4 years. But none of that is quite out of the gates yet, and I really anticipate that we'll start seeing things in the fall. So what we might do is delay that regulatory roundup a little later in the year just to see if we can pick up some more activity. Today's presentation is you're just getting me. Sometimes, as you all know, we try to incorporate several people from our practice and from other areas within the firm, but incentive compensation, we do have a couple of other folks who do some incentive comp work, but it is one of the areas where I personally spend a lot of time, and so I am the sole presenter for the topic today. As I mentioned, I'm the chair of the higher education practice and have been in the business for about 20 years and working on incentive compensation matters with colleges and universities for that period of time. Here is our syllabus. So rule, history, and fundamentals. And we indicated in our promotion, for this webinar, promotion is probably the wrong word, but the email that went out letting you know it was coming, that this is an advanced topics webinar. And I want to be clear, it really is. I'm going to spend a fair amount of time on rule history and fundamentals, but here's why. I was thinking about this earlier today. Incentive compensation, this rule really is a wonderful example of sort of a regulatory onion, right? Using the old metaphor. The rule itself is not a lot of text, but there is a tremendous amount of nuance involved, and as you peel back that text and think more about what seems like conceptually a pretty straightforward rule, you begin to realize that it really is not straightforward at all. There are a lot of different layers and considerations. And to understand all of that, and to really appreciate where we are now and some of the vagaries that exist right now in understanding the law and practices around it, and where we might be going in the future, it's critical to understand the history of this rule and the guidance that's out there currently. So we're gonna intentionally take some time to go through that, but I don't want you to mistake that for a incentive comp 101 concept. That's really essential to getting into and understanding these more advanced nuances. So we'll spend a fair amount of time walking through sort of where this rule came from and the thinking from different administrations over time. And then we're going to move into compensation based specifically on retention, completion, or placement, executive compensation, token gifts, and bundled service providers, which includes OPMs, which we'll talk about, like I said, towards the end, and I know is a very hot topic these days and a place where incentive comp questions routinely arise. I will also say here at the outset, boy, there are a lot of other areas you could explore with incentive comp beyond just these sort of 4 that I've cherry-picked. And if you all want to talk about other areas, of course, you can ask questions now. If you feel like there's a lot left to be explored at the end of the presentation, let me know. It's one of our survey questions is what do you want to hear next? And I would always be happy to consider doing a second round on incentive comp because it really is such an interesting rule, and I think that there will be movement on it in the future. Okay. Deep breath. So let's start with, like I said, rule history and fundamentals. Statutory language, the incentive comp statute, and it is in statute, always an important thing to note. This is not strictly something that exists in regulation. The statutory language has been more or less unchanged since it first debuted in 1992, right? So, and that's another important point. So we're going to spend the rest of the presentation talking about all the changes from one administration to the next in sort of regulatory approach and all of the sub-guidance that's come out and sort of where institutions are right now and trying to understand what's okay and what's maybe not so okay. But it is important to note that the statute itself has been the same. It has been consistent for this entire period of time. So I'm just going to read it because I think it is important. I mentioned earlier, it's not a long statute, but all this nuance is built in. I thought at one point about highlighting some of the words and phrases here in the statute that are most important, and I ended up with the whole thing highlighted because virtually every phrase, like I say, is a layer in the onion, right? Okay. So another thing that's important to note is the incentive comp requirement applies to all institutions of higher education that participate in the federal financial aid programs, and compliance with the incentive comp prohibition is embedded per the statute. It's part of your program participation agreement. So the statute actually dictates certain items that have to be in that program participation agreement that you sign with the department, and then there's a regulatory corollary in the regulation where it goes through and says, yes, these are all the things that go in the program participation agreement. That's where the prohibition exists and always has existed, is in the program participation agreement. So statutory language, the program participation agreement shall condition the initial and continuing eligibility of an institution to participate in the Title IV programs, right, with the following requirements. And of course, in the statute, there's a whole bunch of them. But if you go down to item 20, right, it says the institution will not provide any commission, bonus, or other incentive payment based directly or indirectly on success in securing enrollments or financial aid to any persons or entities engaged in any student recruiting or admission activities or in making decisions regarding the awarding of student financial assistance, except, and this is interesting, this carve-out is in the statutory language. It's the only carve-out in the statutory language, except that this paragraph shall not apply to the recruitment of foreign students residing in foreign countries who are not eligible to receive federal student assistance. So if you are, you have a recruiter that you've engaged who is overseas, and that individual is strictly involved in recruiting foreign students who are residing in those foreign countries. And keep in mind, we're not talking about someone recruiting potentially non-immigrants who are already in the United States, right? We're not talking about someone who might be overseas recruiting expats who are eligible for Title IV and just living overseas. We're talking about someone who's recruiting folks who are in a foreign country, they're a foreign student, they're residing there, and they're not eligible for Title IV. The other thing I'll just mention as an aside is there are in the regulations that are administered by the Student Exchange Visitors Program under ICE, there are some restrictions around incentive compensation and recruiting and such that the folks who are administering your SEVP program on site for you, your PDS, those folks have limitations around how they can recruit. So that's a different body of law, but just keep in mind there actually is another body of law out there that has a little bit to say about how you compensate individuals involved in your foreign student recruiting and programming. But today we're just focused on this provision, right? Okay, so there's a lot to unpack here. Of course, as is often the case, after this statute came into being, back in 94, the Department of Education, or actually 92, the Department of Education turned around and said, okay, now we got to create some regulations to go along with it. And the department had a few thoughts. First of all, in the preamble to the commentary for the proposed rule, the department indicated that it intended to extend the provision to require that institutions also may not contract with entities that improperly provide any commission, bonus, or other incentive payment as delineated in the statute. So the idea here is, and this is understandable, they're saying, look, the statutory language itself, and if we go back, I'll flip back a slide. Remember, the statutory language says the institution will not provide commission, bonus, et cetera. And what the department was saying is, yeah, but it wouldn't make sense if the institution could just contract with a third party and then they could do it. Right? I mean, that's an obvious workaround. And the whole point here is we're trying to avoid a situation where students are being recruited by individuals who are incentivized, right, in this way. So whether that's directly by the institution or through a subcontractor of the institution, either way, what we're saying is these restrictions apply. Okay, and so right out of the gates back in 94, the department said, yeah, we want to make sure to extend this regulation in a way, or write the regulation in a way that makes clear that it's not only institution, but anyone with whom the institution might contract. The department also observed that some institutions pay incentives based on recruiting success, provided that the enrolled students maintain satisfactory progress for and remain enrolled in the institution for some specified period of time. And the department said, way back when in 1994, it considers this practice, commonly referred to as incentive based on retention, to be an example of an activity that is prohibited by the statute. So we're going to talk about later compensation based on retention, completion, right, other types of outcomes metrics. But I just want to highlight right out of the gates that way back in 1994, the department went on record in the Federal Register as saying specifically that we believe compensation based on retention is an example of an activity that is prohibited by the statute. So keep that in mind. We'll talk about it later a little bit more. The department in 94 also took on this notion of token gifts, another topic we're going to get to later. And in that commentary, the department said that the acceptability of token gifts for students and alumni who refer other students, or the department rather said, you know, we think it's acceptable. And the secretary sort of noted that after reviewing comments, the department determined that practices are widespread and will cause no harm if the tokens are not monetary and limits are placed on their value and the frequency of distribution. So a couple things to remember. Way back in 94, first of all, the department out of the gate says, we think retention violates, or compensation based on retention violates this law. And the department also says at the same time, you know, we don't think token gifts for referrals to students or alumni violates the law, provided they're made within some parameters here. So then we got the rule, and this was the entirety of the incentive comp rule back in 1994. First of all, it sort of restates the first half of this, restates the statute more or less, although you can see in red the department has inserted that the institution will not provide nor contract with any entity that provides any commission, bonus, et cetera. So per their comments, they inserted this provision to make clear that this extends also to parties with which the institution contracts to provide these types of covered services, meaning recruiting or financial aid services of a certain type. And then at the end, the department actually adds, after the carve out for foreign students, adds specifically in the body of the rule a line that makes clear that the provision does not apply to the giving of token gifts to students or alumni. And here they offer up those parameters that they suggested in the commentary. They say, look, as long as the gift's not in the form of money, cash, right, check or money order, no more than one such gift is given to any student or alumnus, and the gift is a value of not more than $25. So truly a token gift. But what's interesting is, not only did the department say that they were okay with it, but they actually addressed the token gift idea in the text of the regulation. What's also interesting is, despite their very strong language around retention, what you do not see in this regulation is an explicit reference to compensation based on retention. Now, that doesn't mean the department didn't feel that that was a violation of the rule, but it is interesting that when they actually put together the regulatory text, notwithstanding their strong feelings on the topic, they didn't include that language, even though on the other 2 points, contracting with third entities and the provision of token gifts, they did include this specific language. Okay. So then we have this period of 1994 to 2002, during which we had what I call here a web of private guidance. And I got a great quote here from an expert report and affidavit of the great Blaine Butner, who I worked with for many years at a law firm in D.C. called Dallona's and their higher ed practice, which later became the Cooley higher ed practice. Blaine is now retired, but for a very, very long time, I think was one of the foremost experts on incentive comp, probably still is, even retired. And he had this great line out of his expert report, and it was so good that I just wanted to include it as it was written. It says, as a result of the lack of precision in the incentive compensation requirements, many schools asked the department for guidance. Inquiries were in the form of written letters, and often department policymakers provided a written response to the person making the inquiry. However, those letters were not disseminated by the department to the higher education community at large, nor were they incorporated into any of the department's guidance publications, right, like the FSA handbook, things along those lines. And over time, the department officials who issued these guidance letters occasionally provided contradictory advice. So, and I was practicing I started practice right at the end of this period, and this was very much the case, right? I mean, we law firms that did this kind of work, we collected all of these letters from clients and others, and they were inconsistent across the country. They didn't always land in the same place, even when comp plans were very similar or practices might be pretty similar. And so you had a lot of confusion. So in part, in an effort to address that confusion, the department decided in 2002 to go back to the incentive comp drawing board and try to flesh out the rule a little bit. And so they added these new 12 safe harbors. And in the preamble to the proposed rule, the department talked about sort of 12 types of activities and payment arrangements that an institution could carry out without violating the incentive payment restrictions. And so the idea here was, you had folks saying, look, there's all this confusion, there's been all this, I won't say always contradictory, but, just not consistent and difficult to discern and not public information about what's okay here. And so the community was saying, we really feel like we need some additional detail because we may want to do things and we think they're okay, but we're not sure they're okay, and it would be very helpful. And so the department, in response to that, among other things, said, okay, we're going to kind of come up with some buckets. And if what you are doing fits in one of those buckets, it would be okay. So the department, and here you see in the second bullet explained that the list of safe harbors is derived from compensation and payment plans that the majority of the negotiators, so this process went through negotiated rulemaking, as is the case these days with the department's rulemaking. These are concepts that negotiated rulemakers, the majority of them anyway, agreed would be okay, should be included in the regulation. And they provide schools with specific concrete examples of payments they can make without violating the law. So I want to go through these. As we're going to see in the next slide here in just a minute, these have been pulled off the books. But but the subsequent rulemaking that pulled them off the books was responding to these. And subsequent interpretations, even today, of what's okay and what's not okay are often influenced by and sometimes referenced back to some of these concepts. It's also helpful to see where things like token gifts were viewed as okay by multiple administrations, or where things that one administration thought was okay then weren't, et cetera. The other thing that this illustrates, these 12 safe harbors illustrate, particularly for those of you who may not have as much familiarity with this rule, is just how far-reaching it is and the types of things that can be touched by this incentive comp prohibition, right? Adjustments to employee compensation. So there has always been question, right, and the department certainly has looked very seriously at over the years situations where there is an employee, I'll say, someone in your enrollment office or admissions office who's had multiple compensation adjustments during the year, right? And by the way, let me take a step back here for just a second and say, every version of this regulation makes clear that you cannot provide incentive compensation payments, prohibited incentive compensation payments, right, either to recruiters or admissions personnel for covered recruiting activities or to financial aid or other persons for success in the awarding of financial aid. But as a practical matter, in the 20 years I have been doing this, I have never had anyone call me and say, we've got a comp plan for our financial aid folks, or we've got a concern about how we're compensating our financial aid folks, ever. Every incentive comp inquiry I think I've ever had has always been either around, admissions and recruiting type activities, or separately around tuition or revenue sharing agreements. And even there, the underlying concern typically is covered recruiting activities, right? So I'm going to be focused primarily on the recruiting and admissions component of this and not on the financial aid component throughout this conversation. And you will also note that most of the 12 safe harbors are really focused on the recruiting and admissions side. But I do want to be clear that the law absolutely applies to persons and entities that are involved in the awarding of financial aid and restricts how you can compensate folks based on success in the awarding of financial aid. So that is part of the law. It's just not where most people have questions that arise. Okay, adjustments to employee compensation. So typically what we're talking about here is, you've got someone in your admissions office who had their, and let's say you don't have an incentive comp plan. You don't have any kind of bonus plan or anything like that, but you've got an individual whose compensation was adjusted 4 times during the year. And the department years and years ago said, well, this is just an end run. Right? I mean, this is a school finding a creative way to, in fact, incentivize someone or give them a bonus, because what they're doing is they're adjusting their annual compensation up 3 or 4 or 5 times during the year based on their success, right? And so the department said, look, you can do compensation adjustments, but you can only do it twice during any 12-month period. And it can't be based solely on their success in recruiting or financial activity, right? Enrollment in non-Title IV programs. So there's always a question around, well, what if I've got recruiters out there and they're enrolling in programs that aren't Title IV, and the students enrolling in these programs aren't Title IV, right? I mean, is the incentive comp also extend to that? And it's not always been real clear, right? But here there was a safe harbor introduced saying, yes, you can compensate the recruitment of students if they are only being recruited for and enrolling in non-Title IV programs. Contract training with employers, another example. There was a question as to whether or not, if you've got someone out there who does what I'll call business-to-business type recruiting. So they're out working with businesses, and they are trying to put together arrangements where the school might, pursuant to contract, provide training directly to an employer, right? And the question is, could you compensate those individuals who you probably wouldn't even think of as recruiters, right? But those individuals who are out there working to develop those relationships, particularly since they don't have any involvement typically with prospective students. A lot of times the ones doing that kind of development work, those types of individuals, have no contact with prospective students because, again, they're doing business-to-business work. They're talking with executives at some company or employer that the school's looking to develop a relationship with. And here the department said, yeah, that's okay as long as the recruiters are arranging contracts between the institution, the employer, it's the employer's employees, the employer's paying for it, et cetera. And there's a little more on the bone, by the way. Some of these on the right are paraphrased. So please, if you're looking to get the exact regulatory language from the regulation Circa 2002, you should go pull it. And I have a link to it, by the way, here coming up later. Profit sharing and bonus plans. So the department okayed compensation paid as part of a profit sharing or bonus plan, provided the payments were substantially the same amount or the same percentage of salary or wages and made to substantially all full-time staff. Compensation based on program completion. And as I've already indicated, we're going to talk about this more later. But in 2002, the department took the view and actually included an explicit safe harbor that said compensation based on students successfully completing their educational programs or one academic year, whichever is shorter. Now, what's interesting here is, remember in 94, the department said, we believe comp based on retention is not okay. That violates the rule, all right? there is an important distinction between retention and completion, and I know most of you who are at schools appreciate this, but folks who aren't may not totally get the distinction. So completion, we're talking about completing the program, all requirements related to the program, ostensibly ready to walk and graduate, right? And in my mind, completion and graduation are more or less synonymous. But retention is not synonymous with completion and graduation. Retention could be, they successfully get halfway through their program, or they finish the first year, or they make satisfactory academic progress for, over some period of time. But it doesn't mean that the person gets comped based on the students completing the program. It means they get comped based on the student achieving some benchmark short of completing the program. And what's interesting here is the department leads with completion, but when it says or one academic year, whichever is shorter, I mean, that's essentially a retention metric, right? Because if you've got a program that's 3 or 4 academic years, the department's saying you could comp someone based on the student successfully completing the first academic year. So that's not a completion like I completed the whole program and I'm ready to graduate. That's a retention concept because the school has essentially been successful in retaining the student for a fraction or a portion of their program. So this is interesting. So here we've got a safe harbor that at least in part departs from the feelings of the department in 1994. Pre-enrollment activities, so compensation paid to employees for clerical pre-enrollment activities such as answering calls, referring inquiries, or distributing institutional materials. Then we've got our next 6, managerial and supervisor employees. Okay, so if you're compensating managers who don't directly manage employees who directly are involved in recruiting or FA activities, so, maybe you're president or CEO or someone along those lines who is setting policy and at the very top of the organization, but is not engaged in directly managing the folks in the admissions office or in the financial aid office. Token gifts. So in 94, the department was okay with it, and here again in 2002, the department actually puts token gifts. They take it out of that, sort of primary piece of the regulatory text, and then they're going to put it into its own safe harbor. And they're going to say, if you're giving a token gift to students or alumni, it's okay, provided the gifts are. And here we see the department up the numerical amount a little bit. It was $25. Of course, that was in 94. 2002, there's been some inflation. So now they say it still has to be, it shouldn't be money, right? No cash. No more than one gift is provided annually to an individual. So in 94, it was just you couldn't do more than one gift to a student or alumnus. Here it's within a year. And the cost of the gift, and they move it up to $100. But still the idea is this is a token, a nominal concept. Profit distributions, all right, as long as they're proportionally based on the individual's ownership interest. Internet-based activities, and remember in 2002 the internet was only about 7 years old, so this was very forward-thinking at that point in time. So compensation for internet-based recruitment activities that provide information to refer prospective students or permit prospective students to apply online. It's interesting what you see here is that in 2002 folks were still thinking of, quote, internet-based, end quote, recruitment as something very different from normal recruitment. It was sort of like off to its side, right? Otherwise, it's kind of hard to justify drawing a distinction. I think today, for most of us, drawing a distinction doesn't necessarily make sense because we sort of think of whether it's online or through texts or social media, all of that is just part of your recruiting and admissions activity. Carving some of it off and putting it into a box and suggesting it should be treated differently doesn't necessarily make sense given what this rule is about. But in 2002, it seemed to make sense to folks. Third-party payments for non-recruitment activities. So payments to third parties that deliver bundled services. Now, I want to be clear. The 2002 regulatory language did not use the phrase bundled services. I put that in, but that's essentially what they were getting at. Payments to third parties that deliver a grouping or bundle of services, provided that none of them involve recruiting or FA activities, right? And then there was this concept of payments to third parties that deliver bundled services that include recruiting or FA activities, so long as the individuals performing the recruitment or FA activities aren't being compensated based on an incentive compensation model. Okay, so that was your 12 safe harbors, and for many years, they remained on the books until 2010. And that was the next time under the Obama administration when you had a department that said, we don't like the way incentive compensation is being regulated, and we think that we need to go back to the drawing board. I'll also note, I think I don't know if they've tuned in, but registered for today's program. We had a couple of folks from the GAO office. And as a nod to them, in 2010, the GAO actually had a report that came out that was critical of the department's regulation of an enforcement of the incentive compensation provision, which I'm sure was, I don't know if that was spurred the department to action or was designed more to support action that was already being planned, but either way, just as a nod to the GAO, they were in the fray at that point in time. So the department came back and said, look, we understand that these 12 safe harbors were put out there in 2002, but we think they've created more harm than good, right? Our experience demonstrates that unscrupulous actors routinely rely upon these safe harbors to circumvent the intent of the incentive comp prohibition. And as such, rather than serving to effectuate the goals intended by Congress, the safe harbors have served to obstruct those objectives. So in the commentary to the proposed rule, the department then went through and detailed each of the 12 safe harbors reflected in the current regulations and stated why it viewed them as either inappropriate or unnecessary. And I don't think it's a spoiler to let you know that the administration at that time felt like all 12 safe harbors should be removed. So they were all either inappropriate or unnecessary. The 2010 rule commentary also included this two-part test, which with all due respect, you know, to the folks who drafted the commentary, I've mainly included just because I think my guess is many of you on the institutional compliance side will sort of chuckle here. So in the commentary, when they removed the 12 safe harbors, the department said, we believe that institutions can readily determine if a payment or compensation is permissible by analyzing whether the payment's a commission bonus or other incentive payment, and whether that commission bonus or other incentive payment is provided to any person based in any part, directly or indirectly, on success in securing enrollment or the awarding of financial aid. If the answer to each of these questions is yes, then you would not be permitted, the payment would not be permitted under this statute. I mean, the reason I'm sort of laughing is because this essentially is like saying, look, it's a simple test. You just read the statute, and if you violate the statute, you violate the statute. Because the two parts of the test are essentially just the two components of the statutory and regulatory language. It really doesn't help when you're talking about, well, what is a commission or bonus or incentive payment? And, you know, who is a person? And, you know, what does it mean to be directly or indirectly? And all of these things that were in the 12 safe harbors, and that sort of demonstrate the breadth of things that can be touched by this rule, you know, business-to-business contracts and all those kinds of things. It's really, in practice, very hard to sometimes discern whether it would be okay or not. And I don't think the two-part framework is very helpful, candidly. The good news is the department did provide a great deal of guidance a little while later, and we'll get to that in a minute. The other thing the 2010 rule did that, I don't know, helpful may not be the right word, but certainly goes a long way to assisting you to understand how the department in 2010 felt about the rule and you know, their view on how these critical concepts should be interpreted. For the first time, they offered up several definitions. And this really is, again, I mean, I don't know how helpful it is, but it's certainly, I think, a step in the right direction, right, if you're the regulated community and you've got a rule like this that is so nuanced. So the department, when they first laid out the 2010 rule, they just restated the longstanding sort of fundamental prohibition requiring each institution to agree, and you can see it here in quotes, basically that they won't provide any commission bonus, incentive payment, et cetera, on success in securing enrollments or the award of financial aid. However, for the first time, again, the department defined the key phrases here. And when I say the key phrases, I essentially mean they broke down almost every element of this foundational concept, this sentence in the first bullet, and defined it. So, commission bonus or other incentive payment, a sum of money or something of value other than a fixed salary or wages paid to or given to a person or an entity for services rendered. I cannot tell you how many times over the years I have had a school reach out to me and say, well, I know I can't pay my admissions or enrollment personnel, et cetera. I mean, obviously I can't give them a cash bonus, but what if we did, like, you know, we have this great parking spot up at the front. And what if, like, the person who has, you know, the best month gets the best employee parking spot? And I always tell them, look, what the rule says is something of value. Now, I'm not sure the department would go so far as to say a parking spot is a problem, but I think you have to be mindful of the fact that commission bonus or other incentive payment is not defined as cash, right, or something of quantifiable cash value. It just says a sum of money or something of value, which could be things that are not cash and have value of some other kind to your employees. So you have to be careful about that. You know, if you're taking the admissions team to Dave & Buster's, that is definitely something of value, even if you're not giving them cash, right? So just keep in mind there is a definition on the books, and beyond that, I'm quite confident that the department does not feel confined to defining this as a sum of money only. Anything of value is potentially a problem, and you should be very thoughtful about if you're planning to give your, admissions or recruiting personnel or anyone else who's engaged in covered recruiting activities, if you're going to reward them for their success, it can't be with something of value, right? Okay, so keep that in mind, other than the fixed salary and wages, by the way. Enrollment, this is an easy one, admission or matriculation of a student into an eligible institution. Okay, securing enrollments or the award of financial aid. This is an important one, right? So activities that a person or entity engages in at any point in time through completion of an educational program for the purpose of the admission or matriculation of students for any period of time or the award of financial aid to students. I just want to pause here. Some of you, if you're like me when you read this sentence, and I know I'm covering a lot of ground, but if you've really let it sink in, you might ask the question, what activity could I engage in that would be for the purpose of the admission or matriculation of students, but would occur after their admission, right? So if I've got a student who's halfway through their program, what activity am I engaged in that could be for the admission or matriculation of that student? It's a little unclear. And I think what you see here is this administration, and you're going to see it later too, but they had very strong feelings that compensation based on completion or graduation should be prohibited, right? They took out that safe harbor. We already know that. And they also, in these definitions, I think, were working hard to make that plain, to try to indicate that anything that relates to completion is potentially violative of the rule. But if you read this sentence, it is a little hard, at least for me, to contemplate what we would be talking about here. I mean, if I've got a recruiter who is tasked in part with sticking with students and making sure even after they matriculate that they are successful, and who is tasked with checking in with them periodically throughout their program, it's still unclear to me how checking in halfway through would be for the purpose of the admission or matriculation of that student, right? Second bullet, these activities, so when we're talking about covered enrollment or awarding of financial aid activities, I'll just say covered recruiting activities here forward. So we're talking about covered recruiting activities. So these activities include contact in any form with a prospective student, such as, but not limited to, contact through pre-admission or advising activities, scheduling an appointment to visit the enrollment office or any other office of the institution, attendance at an appointment, or involvement in a prospective student signing of an enrollment agreement, etc. But the thing I wanted to highlight here, because I also have folks regularly call me, say, well, what about this or what about that? Talking about some sort of activity and trying to understand if it's what I would call a covered recruiting activity. And for me, you know, and often these, whatever we're talking about is not one of these that are very clearly articulated here. But I think a rule of thumb, and it is just a rule of thumb, right? But I think a workable rule of thumb here is the department, the regulation really emphasizes this notion of contact in any form with a prospective student, including but not limited to contact through, et cetera, et cetera, et cetera. So the starting point for me when I'm evaluating whether an activity is covered or not is always, does the activity involve contact with the prospective student, right? Or is it an activity that is more along the lines of promotional or marketing assistance or things like that? And as we'll see in a minute, the department actually has in its guidance a table that they have created that you should absolutely have handy if you're ever evaluating incentive comp questions. And they actually went into more detail. And it's a table that articulates, by example, covered and non-covered recruiting activities. And it helps further distinguish between the two. And I think it also consistently puts anything involving contact in one category, covered, and anything that doesn't, I shouldn't say anything, but, you know, and typically the activities that the department deems or provides as examples of not covered activities don't involve contact, put it that way. Okay. Entity engaged in any student recruitment or admission activity or in making decisions about the award of financial aid. The last piece, right? So you can't provide the prohibited payment to any person or entity, right, engaged in these activities. So the department says, well, if we're talking about entity, we're talking about any institution or organization that undertakes the recruiting or the admitting of students or that makes decisions about and awards Title IV HEA program funds. So to be clear, if you're subcontracting with someone, right, any institution or organization, so entity would include someone you might be subcontracting with. Now they're not, this is another important point. If you subcontract with another entity out there to go assist you with your recruiting, I mean, they're not directly subject to the incentive comp rule. The incentive comp rule governs institutions participating in Title IV, but you are as an institution, and you as an institution would be on the hook if you contracted with a third party and that third party then carried out recruiting activities and paid their folks in a way that violates this rule. Which means, by the way, that if you are contracting with third parties, you want to make sure in those contracts that you include, first of all, obligations that they comply with the rules. Second of all, some sort of audit right or, you know, mechanism for periodically monitoring them and revisiting their activity because you want to make sure that they're complying with the law. But here's the one that I thought was extremely interesting. We'll talk about this later too. A person engaged in any student recruitment or admission activity or in making decisions about the awarding of financial aid. And here's the definition the department came up with in 2010. Any employee who undertakes recruiting or admitting of students or makes decisions about and awards Title IV, et cetera, et cetera. And they say this includes any higher level employee with responsibility for recruitment or admission of students or making decisions. But the thing I want to highlight here is the statutory language, right? I mean, and the regulatory language just uses this term person. So if I'm just reading the statute, it doesn't just prohibit an institution from paying employees. I think you could read it to say it also prohibits an institution from paying any person, whether they're an employee or not. Alumni, students, right? But interestingly enough, the department here offered up a definition of person that restricts the definition to employees. And when we talk about token gifts in a minute, we'll see how that impacts that consideration. And, you know, I don't know. I've never talked with anyone at the department about this, but I think if you went back in 2010 and highlighted this issue to the folks who are drafting the regulation, they would probably change it. And my gut is it was not intentional. But as a technical matter, that's what we've got. We've got a law, a regulation on the books that explicitly says the definition of person engaged, et cetera, is limited to employees. It's interesting. And if I am an administration right now who's considering revisiting this rule, I can tell you this is one of the things I'm probably thinking about changing. By the way, I'm not giving away any goats here. I know that this is known. This issue is already recognized. Okay, so three other things that the 2010 rule did. And by the way, the 2010 rule, I should also say, is the current rule. We've not had another revision of this rule since 2010. So I'm spending a lot of time talking about it because it's what we've got now. And the preamble, et cetera, that accompanied this rule is the preamble that accompanied the current rule of law, right, or current law. So important to note, again, the 2010 rule also echoed the statutory carve-out for foreign students. The 2010 rule also includes, and so again, the current rule also includes, sort of embedded in the definitions, some commentary. I shouldn't call it commentary because this is in the regulation, but some concepts around compensation adjustments. So the rule creates a presumption. They don't use this word presumption, but I read it as a presumption that compensation adjustments for employees engaged in recruiting or FA violates the rule. So remember, we used to have a safe harbor that said if you make these adjustments up or down, right, more than 2 in a year, et cetera, then you're in trouble. But as long as you keep it to just a couple in a year and you comply with these other requirements, it's not solely based on recruiting or FA, you should be okay. The administration in 2010, the Obama administration, felt like there was a lot of abuse around this safe harbor. And so they decided not only to get rid of it, but they also included in the current rule, right, the 2010 rule, which is still current, some explicit language around these compensation adjustments. And they said, look, an employee who receives multiple adjustments, and I'm going to read multiple to mean more than one, right? I think that's the conservative view and the one I would suggest folks take. An employee who receives multiple adjustments to compensation in a calendar year and is engaged in any student enrollment or admission activity or making decisions regarding FA. So again, we're talking about an employee who's engaged in some sort of covered recruiting or FA activity. If that individual receives multiple adjustments, right, then those adjustments are considered to have received, or that employee is considered to have received such adjustments based on success in secured enrollments or the awarding of financial aid. And then there's this trailing language, if those adjustments created compensation that is based in any part, directly or indirectly, upon success in securing enrollments or the awarding of financial aid. I'm just going to tell you, the way I read this is, if you have an employee who is engaged in covered recruiting activities or FA activities, but I'll just say covered recruiting activities, and they are getting multiple compensation adjustments, I believe what the department is saying here in the law is that will be considered to be, those adjustments will be considered to be based on success in securing enrollments or the awarding of financial aid. And I don't think the trailing language really makes any difference, because I think it would be very difficult, and certainly the burden is on the institution, if necessary, to demonstrate that those adjustments were not based in any part, directly or indirectly, on that individual's success in securing those enrollments or awarding financial aid. So I think the intent here, and there has been discussion around this, but the intent here was to create a presumption and say, if you're going to do adjustments for folks who are engaged in covered recruiting activities, our starting point is going to be that those are based on their success in those covered activities, and you, the institution, are going to have to demonstrate otherwise. So keep that in mind. I still get questions all the time from clients about, and often they echo the old safe harbor. I believe there are still schools that think that safe harbor concept is out there. Well, if I only do 2 or 3 adjustments, it's not a big deal. And I will just tell you, I think if you are adjusting the compensation, and I know this is difficult because you may have someone who, got promoted, and then the person above them retired or went to another school, and you ended up promoting them a second time, all within the same 12 months. And now you've got potentially 2 compensation adjustments for someone who's engaged in covered recruiting activities. I'm not telling you it's impossible to do that. But what I'm telling you is, the way the law reads, that there is a presumption that those adjustments were actually made to award that person for the success in carrying out their covered recruiting activities. And you're going to have to be prepared, the burden's on you, and you're going to have to be prepared to demonstrate otherwise. There were a couple of carve-outs. So despite including this bit about compensation adjustments and sort of creating this shifting of the burden, the department did also, in the rule itself, in the regulation, note that merit-based compensation adjustments are permitted provided they are not based in any part, directly or indirectly, on success in secured enrollments or the award of financial aid. So merit-based compensation, right, just meaning that if you've got qualitative criteria in place, let's say hypothetically, you have a policy that says when anyone reaches 3 years with the company, and and assuming they've shown up on time and they've not been written up for any violations of the code of conduct, then that person automatically gets an increase in their salary, right? I mean, those are all sort of qualitative merit-based compensation adjustments that are not related to any sort of metric tied to, or that would ostensibly be a proxy for recruiting activities. And I think what the department is saying here is, in theory, if you can demonstrate that those adjustments were, merit-based, then they're okay, because in that case, they're not based in any part directly or indirectly upon success in securing enrollments or the award of financial aid. Similarly, the department is specific about approving profit-sharing payments that are and saying they're permitted so long as those payments are not provided to any person or entity engaged in covered activities, right? So what that means is, if you're doing profit sharing, though, you want to be careful about thinking about whether making sure that those folks are not engaged in covered recruiting activities or making decisions around the awarding of financial aid. Okay. The other thing that the department I'm sure, after a lot of conversation when it was creating the rule, was careful about, in the rule itself, is to create a carve-out for lead generators. That's why I'll use lead generator. I think most of us, many in the space, refer to them that way. So what we're talking about are third parties who, per contract, under a contract, are providing the institution with student contact information for prospective students, right? And if all they're doing, this is typically my rule of thumb with clients when I'm working, I say if they're just providing student contact information, you should be okay. Right? But the department does include a little more detail in the regulation itself. It says, provided that the payment is not based on, and it says, any additional conduct or action by the third party of their prospective students. So they make clear, they're saying, look, even if someone's providing you contact information, that's all they should be doing. They can't also be scheduling appointments or showing appointments or signing an enrollment agreement, et cetera. And this, one of the things that this highlights for me, and I have this conversation regularly too with clients, is, you may start out with a company, a third party, and they say, hey, all we're going to do, we're just going to provide you contact information. And you call somebody like me, your attorney, and you say, hey, is this okay under incentive comp? And I say, yeah, it is. And then a couple of years go by, and whoever's managing that marketing relationship gets a call from the third party, and they say, hey, we've got this great new platform, and now we can actually, we can schedule appointments. And that person who's on your staff and wasn't involved in the original contract, but now is talking with the third party, says, yeah, that'd be great. Roll it in. We'll update the contract. No problem. Nobody calls your attorney. Nobody thinks about incentive comp. And now you've got a relationship with a third party where they're not just providing you student contact information, but they are also engaged in this additional activity, and that's going to create a problem for you. Again, my advice for institutions is, if you are contracting with third parties to engage in activities, and you're paying them in a way that is okay, but would cease to be okay if their scope of activities were to expand into certain areas, you should be very clear in that contract that these are the services we are contracting for. And I would say two things. One is, you could also very specifically say, we agree that under no circumstances will you engage in these other activities, and any expansion of the scope of your activities must be approved by the parties in writing, et cetera. But you want to try to, in the agreement itself, create some sort of mechanism so that if down the road somebody else is negotiating this agreement or revisiting the agreement, right, that somewhere there's a flag for the parties to say, wait, why is this in here? Because we actually have this provision that says we can't do this. We should at least call somebody and figure out why. Because I'm telling you, all the time what I see is, you start with a contract and a grouping of services that are okay, and then down the road, it expands inadvertently and unintentionally. I want to be very clear. I'm not talking about anybody trying to do anything wrong. It's just a matter of, it expands because something has happened, or the third party now has some great new product or whatever, and nobody realizes that it has pushed you into the incentive comp area, and you've got a problem, right? So try to build things into your contracts that will protect against that and may serve as a flag in the future if the parties are thinking about expanding the scope of their services. Second bullet, the other thing that a lead generator, you can't pay them on is the number of students who apply for enrollment or are awarded financial aid or are enrolled in the program, including through completion of an educational program, right? So again, it permits payments to a third party for the provision of student contact information, right? Provided that payment's not based on the number of students who actually apply for enrollment or are awarded financial aid, including through completion of the program. So again, what you can pay them for is the amount of contact information you get, but not for how many of those contacts they send you end up being successful and enrolling successfully. So if you've got contracts like this, make sure they're structured the right way. Also, I just want to highlight here, you see I've put in red completion. Here again is another example of the department, when it drafted this regulation, being very thoughtful about getting at this notion of completion and comp based on completion, right? So they say not only can you not pay a lead generator based on enrollment, but you can't pay them based on how many of the leads they send you actually end up enrolling and completing a program. Okay. So we had this new rule. The 12 safe harbors were gone. People had lots and lots and lots and lots and lots. And the department, to its credit, spent some time with those questions and came up with guidance in 2011. They issued a Dear Colleague letter. I got a link for you here to the Dear Colleague letter. It's also really important to note that the text of the Dear Colleague letter has been restated verbatim on the department's website on this page, you see the image right here, Program Integrity Questions and Answers Incentive Comp. You can click on that link where it says website, and it'll take you to that page. Or I think if you just Google U.S. Department of Education Incentive Comp, this is one of the first hits you get. But what's really important is the website, again, restates the Dear Colleague, or the section of the Dear Colleague that addresses incentive comp, almost verbatim. But at the very bottom of the website, the department has added, it got some subsequent questions in 2012 around bundled services providers and, OPMs, that kind of stuff, tuition revenue sharing agreements. And it added a couple of Q&As. And those Q&As, those that it added in 2012, of course, aren't in the original 2011 Dear Colleague. So if you've got a copy of the 2011 Dear Colleague, great. And that's 95% of what you want on hand. But just keep in mind there are a couple extra things on this website. The other thing is, it's always conceivable that the department could add something more here. They haven't, I don't think, since 2012 or 2014. It's been a real long time. But this is the website where those things exist and where ostensibly something could be added. And this 2011 guidance was really helpful, right? It went through a lot of different topics. So it included a table of covered and non-covered or exempt recruiting activities and FA activities, but again, the focus is really on the recruiting and admission side. It included a table of permissible and prohibited payment types. It includes a discussion of revenue sharing arrangements and Q&A and some examples, a discussion of bundled services providers. And by the way, I've been using that phrase. We're going to talk about this here in a few minutes, but just to be clear, in 2011, the notion of an OPM, OPMs really didn't exist yet, or that acronym, Online Platform Manager, hadn't really come into being. But the department did contemplate the notion that you might have a vendor, if you're an institution, a vendor, some third party with which you contract, that is providing you a bundle of services. And that may include, retention efforts, student services, counseling, administrative back-end stuff. It could even include some form of FA, but it might also include academic and platform support, right? And it might also include recruiting and admission support. Right? So the department sort of gets at this idea, well, what if you've got a servicer or a third party with which you contract that's providing you a bundle of services? So when you call me, and institutions call me, and occasionally vendors, OPMs, will call me as well, and they say, well, what does the rule say about OPMs? My response is going to be, well, it doesn't say anything about OPMs, but it talks about bundled services providers, and it was this discussion and a very important carve-out that we'll talk about in a few minutes that really facilitated the explosion of OPMs in the space, right? Discussion of application of the rule to executives. Examples of qualitative evaluative factors. So we talked about earlier, we talked about merit-based adjustments to comp, and, the department talking about, well, if it's not a proxy for recruiting success, if it's qualitative, it's okay. And so people say, well, what's a qualitative evaluative factor? And the department came up with some examples. Discussions of payments based on academic performance and the application of the rule to study abroad programs. So all of this was covered in the 2011 guidance, again with examples and some very helpful Q&A. And then things got quiet for a little while. And in 2015, they didn't get quiet. Actually, they sort of went to the courts. So what happened was, and we'll talk about this more in depth here in the next section as well, but the short of it is the department got sued over these regulations, and in particular the removal of some of the safe harbors, and in particular the safe harbor around compensating folks based on completion and graduation, retention, success. And in November 2015, following a court battle and a back and forth with the courts, the department reversed its position on completion-based and graduation-based compensation, acknowledging that it, quote, lacks sufficient evidence to demonstrate that schools are using graduation-based or completion-based compensation as a proxy for enrollment-based compensation. Now, this is one of our topics we're going to dive into next, right? But I just wanted to highlight now, in 2015, you had this reversal, and it's a big deal. You had two other things that happened in 2015. The IG issued a report, very critical of the department's efforts to enforce the new incentive comp rules. So the department in 2010, right, got rid of the safe harbors, created these new definitions, and then the IG came along, the Inspector General, always the most popular folks at the Department of Ed annual picnic, right? The IG came along and said, well, they haven't done anything to enforce the new rule, and they haven't provided sufficient guidance and procedures to their staff to enforce the rule, right? And their conclusion was, without these strong procedures and guidance, FSA cannot ensure appropriate and consistent enforcement actions against schools that violate the incentive comp ban, and fines will likely continue to be the predominant enforcement action. So this prompted the department in response to do several things. But one of the most important things, and this is kind of a buried concept here, but really important for everyone to be aware of, there was a reversal on how damages were assessed for incentive compensation violations. So prior to 2002, the general view had been, if the department determined that, you enrolled, you have a recruiter and you were paying incentive comp to that recruiter, in violation of the rule, and that recruiter enrolled 100 students, then the way the department determined damages prior to 2002 was to say, well, all the Title IV that went to that 100 students, you got to pay back. That's a serious pay-it-all-back liability, right? Because you all know 100 students, if they're taking out $35,000, $40,000 a year for their education or more in traditional higher ed, I mean, that can be hundreds of thousands, millions of dollars quickly. So in 2002, the department concluded that when institutions enrolled students, or a recruiter enrolled students, and that recruiter is being paid in violation of incentive comp, for example, the department really suffered no loss. And that opened the door for the application of something called the estimated actual loss formula, right? And those of you who are familiar with this concept, it's what it sounds like. The department has a formula that they use, and they'll say, okay, you enrolled those 100 students, and they took out all this money in loans. But because we didn't really suffer any loss, all we're going to try to do is calculate what was the actual loss to us, right, the department. And usually that's, factoring in interest and repayments by the student, things like that, because the students are paying back those loans. And typically what you end up with when you apply the estimated actual loss formula to a loan balance is a much smaller number. As a practical matter, not only that, but the department actually was getting away from using this whole pay it back concept or even applying the estimated actual loss formula. And in most cases, was just levying fines. And typically those fines for violations of incentive comp were far less than what a total would have been if they had used the old model, the prior to 2002 model, where you just say, well, every Title IV dollar received by any student who was improperly recruited or recruited by a recruiter who was improperly paid, all of it has to go back to the department. So schools in the way of fines were paying back small, relatively, right, still big numbers sometimes, but relatively small amounts compared to what it would have been. And that 2015 report from the IG was, again, really critical of this concept. They said, look, I mean, you're not approaching this in a way that's really penalizing schools. The fines are small. You can apply the estimated actual loss formula. We disagree with that. And so I think in response to that IG criticism, of course, among other things, the department reversed its position on how it was dealing with damages. And it concluded that the department, quote, should calculate the amount of the institutional liability based on the cost to the department of the Title IV funds improperly received by the institution. And the department, and specifically Ted Mitchell, who wrote the letter to James Runcie, who at the time was the COO of FSA, the department said, or Mitchell said, look, we do suffer loss, and we should go back to the pre-2002 model. And that's where the department is now. You should know. I mean, we've been involved in some proceedings in recent years, and the department is very clear that if they're going to calculate damages, it's going to be consistent with this post-2015 methodology. So I've included all the stuff I just talked about. All of those machinations, right, from the original statute all the way through, I've included on these two slides in these timelines, and all the links are active. So if you want to go back and you want to look at the statute or any of these federal registers, the regulations through the years, the litigation, the department's external website, the Dear Colleague, all of it's right here. Okay, so now let's get into some of our specific topics. 303, we'll move through this briskly because I do want to have a little time for questions. Compensation based on retention, completion, or placement. So we've already foreshadowed a little bit where this is going to go. First of all, remember in 1994 we had the department that says, yeah, we think retention violates the rule. We don't think comp based on retention is okay. And, now they didn't include, remember, interestingly enough, retention didn't actually make its way into the regulatory language, but the department was crystal clear in the commentary that they thought comp based on retention was a problem. And then in 2002, of course, the safe harbor was created that the comp based on completion was okay, and to some extent suggested that comp based on retention would be okay, right? If you wanted to comp somebody based on successfully completing one academic year. And then in 2010, the department said, I quote, that this safe harbor permits compensation that is indirectly based upon securing enrollments. That is, unless the student enrolls, the student cannot successfully complete an educational program. And citing examples of abuse, the department concluded it is appropriate to delete the safe harbor. And that was the safe harbor, again, that said that comp based on completion or retention was okay. And then the department went a little further when talking about retention and placement, which they clearly did not like, right? They similarly condemned both, saying, with regard to retention, there's nothing about the making of incentivized payments to recruiters based upon retention that enhances the quality of a student's educational experience. Second bullet, the department's experience has shown that some institutions pay incentive comp to recruiters based upon claims that the student who the recruiter enrolled graduated and received a job, when in fact, and this is the department's point, that the job wasn't really an appropriate job or in the right field of study. And the department says, you know, included among the abuses we've seen is like someone graduating from a culinary school and getting a job entry level at a fast food restaurant and the school claiming that as a placement. And the department sort of backs that into, of course, there can be issues on whether that should be a placement and what was reported to an accreditor and some sort of public placement rate. But separately, the department says that's an incentive comp problem because now you've created an incentive for recruiters and, you know, to either directly or to try to pressure the school, whatever, to count people as placed so that they can get their bonus, right? And then the department just flatly says, and this is in commentary to the 2010 rule, very clear, we believe that paying bonuses to recruiters based on retention, completion, graduation, or placement all remain in violation of the prohibition on incentive comp. So there's no ambiguity here as to what the department's position was. Okay. And then APSCU filed a lawsuit. And this is the Association of Private Colleges and Universities. And it was a large lawsuit, and it challenged a number of the program integrity provisions. But with regard to incentive comp, they said, look, the statute, the statutory language that's been around since 92, does not prohibit compensation based on success in retention, completion, graduation, or placement. And those things are different from recruiting activities, and they're not an appropriate proxy for recruiting activities, right? In fact, they all occur after the student has been successfully recruited and entered the program. And in 2012, the U.S. Court of Appeals for the D.C. Circuit at least agreed that the department hadn't provided a sufficient explanation. And they said, you know, the position that completion-based and graduation-based compensation lacks both adequate explanation and support. And so the Court of Appeals remanded back to the district court and directed them to remand it back to the department so that the department could explain its decision to eliminate this specific safe harbor. So in 2013, the department tried to do that. They issued a Federal Register notice and offered up some additional justification, and then APSCU came right back and said, we still don't buy it. And in October 2014, the D.C. District Court agreed with APSCU and remanded the matter again back to the department saying, look, it's just you haven't justified it yet. We don't get it. And in 2015, the department conceded. And they said, you know, we no longer interpret the law to prescribe compensation for recruiters that is based upon students' graduation from or completion of educational programs. The department also clarified that it will not view references in the regulations. Remember, we talked about those a minute ago, especially a couple of them seemed a little forced, but we said it will not view those references in the regulations to recruit enrollment activities that may occur, quote, through completion, end quote, by a student of an educational program, right, as prohibiting graduation-based or completion-based comp to recruiters. So they essentially agreed that they would not enforce any of the language around completion-based and graduation-based compensation, and that, you know, they were reversing their opinion or backing off their opinion that these violated incentive comp. Okay, so where does that leave us? And I have this conversation all the time with clients. There's no question. I mean, the department was the court was crystal clear. Let me just go back here. In its 2014 decision, the D.C. District Court was very clear in its view that there was no obvious connection between recruiting and completion-based and graduation-based comp. And in 2015, in the Federal Register, the department's language is very clear, right? I mean, there's no question that they backtracked here and reversed their position. But it also is clear from the record that the department believed that completion-based compensation plans and graduation-based retention, all of those things, should be deemed to violate the law. And let's let's all keep in mind that the individuals at the department at that point in time who were making this argument and took that view, many of them are back at the department right now. Okay? That's a big reason why I wanted to go through all this 2010 commentary, because the views that were prevalent at the department in 2010, when these rules, the current incentive comp rule was created, are likely to be the views of the folks who are now back in the department, right? And though the department conceded the right of institutions to compensate on completion or graduation, in that 2015 Federal Register, and there's a link back there on that timeline, so you can pull it up and read it, the department also warned institutions that it would carefully examine any such comp plan, that it would look past the label given to a plan. In other words, we're going to look at what you're actually doing, not just what you call it at the top of the page. And in particular, the department called out shorter programs. Because for shorter programs, the time between enrollment and completion or graduation is shorter, which means that the department has a stronger position if it's saying that the completion and placement really is a proxy for enrollment success. If you've got someone who's enrolling in a bachelor's degree program, you got a 4, 5, 6-year delay even between when they enroll and when they would graduate. But what if they're in a 6-week commercial driver's license program? Well, then paying someone based on completion of that program starts to look a lot more like potentially paying them based on the success of getting folks in the door in the first place. And because shorter programs have higher completion rates, it actually makes it even harder to dissuade the department or a regulator that there should be a distinction recognized there between the success in recruitment and the success in graduation or completion. Also, and this is really important, please note, the department did not concede the permissibility of compensation based on retention or job placement. Let me say that again. In 2014, the court told the department that you are trying to use enrollment success as a proxy, or success in completion and graduation as success for enrollment. And they told the department to go back to the drawing board, and the department ultimately said, okay, we throw in the towel. But they did not concede their view that comp based on retention or job placement is potentially inappropriate. Nowhere. And the court didn't direct them to do that, right? And in the commentary in 2010, they clearly took the view that those were not appropriate. So right now, if you're considering a comp plan based on retention or job placement, you have to at least recognize, as you are thinking things through, that the APSCU litigation, the court's decision, and the department's 2015 reversal don't address those two things. And the folks at the department right now likely feel very similarly to the folks who were there in 2010 who said, we think job placement and retention comp based on those two items violates the law. Now, the court's reasoning in APSCU versus Duncan strongly suggests that retention-based and placement-based compensation ought to be permissible, in my view. They don't say it, but I'm just saying the reasoning they use to justify why comp based on graduation and completion is okay. They say, well, it's just not an appropriate proxy for recruitment because it happens at the very end of the educational cycle. Well, that same rationale would seem to support a conclusion that retention-based and placement-based comp ought to be permissible, given that both, like completion, are reasonably divorced from the enrollment process, particularly with regard to placement, because it happens after completion and graduation. But keep in mind, again, that that's not clearly articulated anywhere, okay? We did a blog post on this back in 2016, and everything that I've discussed is laid out there. And there's more discussion on the detail, and there are links to some of these, the court filings and things like that if you're interested. And it's all still current. I know you say, Aaron, why are you giving us a link to a 2016 blog post? Because nothing's really changed. And in fact, one of the reasons I'm digging so deeply into 2010 and 2015 and 2016 is because, again, the folks who have just come back to the department are the folks who were there during this time period formulating these opinions. All right, let's see. Executive compensation, this one's easy. I'll go through it quickly. So the department in 2010 expressed some discomfort. They said, you know, everyone is covered. If you're an employee of an institution, it doesn't matter if you're the president or in recruiting, everyone is covered by incentive comp. So if you're faculty, by the way, if you're using your faculty to reach out to students who've withdrawn to see if you can get them to come back, Doesn't matter they're not in the recruiting office. If they're engaged in covered recruiting activities, they're an employee of the institution, and they're impacted by incentive comp. And you got to be aware of that. Similarly, if your president or your executive is engaged in recruiting activities, they theoretically could be covered, particularly if you're a really small school where you've got a president who might actually engage in covered recruiting activities on a regular basis, right? So then the department even says in the preamble, look, the actions of a college president could potentially come within the HEA's prohibition. But in the 2011 guidance, we get some clarity, and I think language that will provide you all some comfort. They say, look, the department says, okay, we make a distinction between recruitment activities that involve working with individual students. And remember, I mentioned earlier there was that table in the 2011 guidance, and there's this emphasis on contact with prospective students. And the department's saying, look, we make a distinction between folks who are actually working and making contact with students and those who are making policy-level determinations that may affect recruitment, admission, or the awarding of Title IV funds. And these are quotes out of the 2011 guidance. They say, look, employees who have titles such as enrollment counselors, recruitment specialists, and enrollment managers have or likely have sufficiently direct involvement in recruitment that incentive comp almost certainly is going to apply to them, right? But senior managers and executive level employees who are only involved in the development of policy and don't engage in individual student contact or the other covered activities in that table will not generally be subject to the incentive comp. Okay? Should be an end quote there. Likewise, a college president or dean who speaks with prospective students about the value of the college or the virtues of attending the institution would not violate the incentive comp prohibition, because the view is not that they are actively engaged in recruiting, even if, they're speaking at orientation or some pre-orientation event. Token gifts. In 1994, recall, the department clearly said we're okay with token gifts as long as they are for sort of a nominal amount. And then in 2002, that administration actually included a token gifts concept in the 12 safe harbors. But in 2010, the department stripped that safe harbor off the books. And they said, look, students oftentimes do things with little reflection if it brings an immediate reward. Not giving a lot of credit to students there. And such things as a $100 gift card constitute a substantial incentive for many students. Further, the fair market value of an item might be considerably greater. A high-value item for which the institution paid a minimal cost could not be considered a token gift. As a result, even the provision of token gifts, right, could be fraught with the potential for abuse. And ultimately, this commentary and the removal of the related safe harbor suggested strongly the department's belief that all gifts to students or alumni should be prohibited, even where such gifts are tokens, right? Because they're saying, well, it may be a token to the institution or not cost you very much. It could be really influential on the student, right? But we get back to that wrinkle I mentioned earlier. So at the same time, the department removed the safe harbor and made those comments, which pretty clearly articulated its view. It also opened the door for token payments to non-employees, because remember, they added that definition of an entity or person engaged in student recruitment or initiation activity. And significantly, remember I mentioned this earlier, that new definition, which is still the definition in place, limits the definition of a person to employees. So the current regulations, at least as a technical matter, seem to exclude from the prohibition on incentive payments or other token gifts non-employees like students and alumni. Again, I believe this was an oversight on the part of the 2010 administration, which brings me to my word of warning. So it just seems highly incongruous that the department would act to eliminate the restriction on total gifts, or rather eliminate the safe harbor for token gifts, right, to students and alumni, when the general purpose of the rulemaking was to tighten and strengthen program integrity, and in particular incentive comp laws. And that when they specifically said in the preamble to the proposed regs that they think gifts to students and alumni create unwanted incentives, and that's why we're taking out the safe harbor. It's hard to imagine that at the same time they intended for that definition to open up the door for those programs. That being said, I'm well aware that there are many, many institutions in all sectors of higher education right now that have programs that include the giving of token gifts to students and alumni for referrals. What I'm saying is you need to be aware of what the department's position was in 2010, and that position may come back around soon, okay? And keep in mind, too, the statutory language simply states that you can't provide prohibitive payments to persons or entities. The statute does not limit it to employees, even though the regulation does. All right, and here's a blog post that we wrote on this topic as well. So similar to the last, it's still actually pretty, not pretty, I mean, it is still current. Finally, bundled service providers. In 2011, dear colleague, for the first time, the department articulated, of course, a general position that any payment based on the amount of tuition generated, right, is an indirect payment of compensation based on success in recruitment, and therefore is prohibited. So let's be clear. The starting point for the department is a tuition revenue arrangement. If you are paying someone, a third party, and you've got a tuition revenue agreement, and they are engaged in covered activities, the starting point is that violates incentive comp. However, in the 2011 Dear Colleague, and let me also say only in the Dear Colleague, not in the regulation or statute, so not in any law, only in sub-regulatory guidance, the kind that can be overturned overnight, by the way. In the 2011 DCL, the department recognizes a new safe harbor, for lack of a better phrase, for unaffiliated bundled services providers, observing that the department does not consider payment based on the amount of tuition generated by an institution to violate the incentive compensation ban if that payment compensates an unaffiliated third party that provides a set of services that may include recruitment services. Right? So the idea is, okay, so you're paying some third party, OPM, any bundled service provider, right, to provide you with a bunch of services. And part of that is recruiting and admissions support, but they're doing a lot of other stuff too. And the department's saying, if they're not affiliated with you, if they generally are a third party, then you can do that. In fact, the department offers even a little more meat on the bones, because they have a couple of examples and they have a little more commentary. And what they really seem to be saying is, again, neither in the law or even in the DCL, the department doesn't define the term bundled services providers. But they do suggest that these tuition sharing arrangements involving bundled services providers are okay as long as they satisfy these parameters. And these are all things we culled out of that and sort of put in one place out of the DCL. The service provider's got to be independent from the institution receiving the services, both as a corporate matter and as a decision maker. Okay, so that entity with which you as an institution are contracting can't have it has to be independent from you. And it's not just in terms of your institutional corporate structure, but also I think in terms of your governance, right, as a decision maker. The service provider also cannot be affiliated with any other institution that provides educational services. This is why other institutions of higher education cannot be bundled services providers or OPMs. This is why some of the biggest, most successful online institutions of higher education can't themselves go out and act as OPMs to other institutions. Because, I mean, not if they want to use a tuition share arrangement, right, or revenue share arrangement, because this carve-out requires, in order for this thing to work, and the safe harbor to be in place, it requires that the entity providing the service is not another institution of higher education. The service provider has to offer a genuine bundle of services. And this is another one, like when I was talking about lead generators earlier. If you are contracting with a service provider and you are relying on this safe harbor in order to be able to use a revenue share arrangement, they have to be offering a bona fide bundle of services. And what I've occasionally seen is arrangements that start out with a bundle of services, and over time, it dwindles to a point where the service provider is only really providing recruiting support. That's a problem. If you are relying on this safe harbor in order to make sure that your bundled services provider or OPM arrangement works, make sure that in your contract you have some sort of provision that says the services can't be modified or cease to include, this bundle, et cetera, without, legal counsel or review, or just something like that to make sure that it doesn't inadvertently dwindle down and you no longer actually have a bundle services provider. The tuition share has to be based on tuition generated as a result of all the services that are provided and provided collectively. That's something else you just want to make sure is very clear in the agreement. The service provider does not make incentive payments to its own employees, and the institution does not make separate payments for the student recruitment services. Okay, here's my word of warning. There are folks out there who do not like this arrangement, including folks at the department right now, including Bob Shireman, who wrote this piece for Inside Higher Ed 2 years ago and was one of the folks who was at the department when that 2011 Dear Colleague was put out. And you say, well, why did the department back then okay that carve-out? And Shireman's rationale in inside higher ed letter is, well, the lobbyists made us do it. Seriously, I mean, that's actually what it says. The department was heavily lobbied, and that's why we ended up doing this. And maybe that's true. I mean, I shouldn't say it like that. It very well may be, right? But at any rate, the department did it and issued the Dear Colleague letter. Here's the problem. They don't like it anymore, right? There are definitely folks who feel like, and this was, remember, before the OPM market exploded. I mean, there were bundled services providers, but nothing like exists today. And so they created this safe harbor in the guidance, and then this market flourished. And now you have thousands of institutions that have contracts with very large, in some cases, OPMs that are providing lots and lots of support and services, right? And Shireman basically says we think those relationships are fraught with abuse or at least invite abuse, and seems to believe that this guidance should be reversed. And he says sort of, I'll say nonchalantly, I don't mean to be so critical of Mr. Shireman, but he says, I think a little nonchalantly, look, you can still have a bundled services relationship. They just can't provide you with recruiting or admissions support, or alternatively, you just have to pay them on a flat fee. I think the folks in the OPM market and the bundled services provider market and the institutions, probably if you were like me, I think there's a general understanding that many of those relationships really don't make sense. There's no way you can share the risk adequately or provide sort of a reasonable or sensible mechanism for payment that doesn't involve a tuition or revenue share. And then sort of the second question is, okay, then you just take out the recruiting and admission support. But for a lot of institutions, that's a critical piece of it. And a lot of what the OPMs bring or bundled service providers bring to the table is real expertise and understanding about, how to identify the students who are most likely to not only be interested in the program, but be successful in the program. They've done a lot of research. They have internal data, et cetera. And if you take that out of the equation, again, it really takes the wind out of the sails of the arrangement, right? I think if the department were to move to try to make a change here, my guess is there would be extraordinary resistance from a very large community, including not only higher ed, but the OPM providers, and that some of the bigger trade associations and others would be involved in that conversation. So I don't think it's something the department would do lightly. But I do think it is important for you all to be aware who have these relationships, and for you who are vendors who rely on these relationships, if you're not already aware, that the department, there are forces, individuals at the department, and important ones, with a strong voice, who believe that these relationships are problematic. And I think this is going to be a gentleman I know who works at another law firm who I respect a lot, indicated his view that this may be one of the biggest issues tackled by this administration. And I think that's very possible. So if you're out there in higher ed, keep an eye on it. If you rely heavily on an OPM or bundled services provider, keep an eye on it. And if you are an OPM or a bundled services provider, my guess is you're already in the know. All right, and with that, I've got some additional resources here at the end: our blog, our webinars on demand, our Title IX training series and compliance materials, our bar defense reporting guide. You can flip through all of this at your leisure. Let's talk about some questions, and I'm happy to hang out for a little bit to try to get to a few, if we've got any. We have a couple here, it looks like. All right, so just to be clear, a recruiter's salary is not considered compensation. Yeah, that's right. So in the regulatory text, as it currently exists, that definition, and I don't have it in front of me right now, but that's right. That definition says outside of your annual wages, right? So typically, I mean, you should consult your attorney, et cetera, but the department has acknowledged that, you can pay your recruiters, admissions reps, financial aid professionals a fixed annual salary. The issue there, of course, that we've talked about is when you get into salary adjustments and promotions, and that can be tricky business if you've got people who leave, and they get promoted into a position that was vacated, and so they end up with an adjustment or two, and, within a 12-month period. You really ought to have a way for folks engaged in covered recruiting activities to track that. Okay. I've got somebody asking about a specific lead generation company. You can reach out to me separately. Are gift cards considered monetary? That is a great question, and one that I have thought about before and been asked before. You may recall in one of the prior iterations, the department, even when it okayed tokens and gifts, and I think this was the 2002 Safe Harbor, still said, excuse me, it still said you can't have, you can't give money, and then it had this language, check or money order. And I think gift cards likely are in that same category of check or money order. I mean, it's not cash in hand, it's not physical cash, but I think they become a little more problematic because they really can function like cash, especially if you're talking about like a preloaded Visa gift card. I mean, what is that if not a money order, right? So I think you have to be really careful. And my advice would be to try to steer away from gift cards if you can. You know, and if you're really thinking about a program along those ways, I would be thoughtful about it. What about lunch for everyone? Yeah, I'm concerned about that, 100%. I think if you've got a group of individuals who are engaged in covered recruiting activities, and they have had a great quarter or a great month, and you are taking them all out for lunch, that is something of value. And I think you have to be very thoughtful about that. You know, I mean, where's the line between a pat on the back and, you know, a full evening at Dave and Buster's with, I keep using that example because I had that come up once, but you know, I'm concerned. I mean, you could take somebody out and everybody could get a $75 lunch at a steak restaurant. I mean, where's the line? You know, I know that's maybe we think about that as different from bringing in pizza, but it's all something of value. And I think schools should be very, very thoughtful about that, right? Let's see. Would a traveling trophy be value? Great question. So this is actually something that I have suggested before. And that is, if you're really trying to find a way to recognize or honor admissions personnel engaged in recruiting activities, so we acknowledge they're engaged in covered recruiting activities, you know, what might be some form of recognition that doesn't have, quote, value? And one thing that I have suggested, I don't have any written counsel from the department. I haven't put this to the department, so let's be clear. But, you know, I have said recognition. It's hard, you know, I think it would be a stretch to argue that recognition has cash value. You know, I mean, maybe it is something of value, but monetary, any of the, you know, I think there comes a point, and I think it would be a tenuous argument, candidly, for the department or someone to say that sort of along the lines of employee of the month, that kind of recognition would be, quote, something of value. I'm not going to say no one would argue it, but in my mind, at that point, you're sort of getting beyond anything that would have any kind of monetary value. I think that's even beyond the parking space. And I have suggested or heard suggested the traveling trophy concept, which is sort of like your picture in the employee month frame, you know, something that you put on your desk, and each month, you know, the person who has the most successful month, you know, manages to speak with the most students or whatever the metric might be. But we're going to acknowledge that it's a covered metric. And we're going to acknowledge that you've got an employee involved in covered recruiting activities, and you are rewarding them in part for the success. And what you're trying to hang your hat on is the notion that you're not actually rewarding them with anything of value. So at the root of the question is, could we take the position that some, quote, trophy, and I literally mean like a, you know, object that they could put on their desk, whether it be sort of the classic plastic trophy or what have you, but something they don't own or get to keep, just something they could put on their desk that would be an item of recognition or a source of recognition. You know, the question is that something of value? I have generally felt pretty good about it. Your attorney might feel differently. Maybe there's some risk there. But I think that gets pretty far away from being something of value personally. Do you have a read on why all the pre-Biden Dear Colleague letters have been classified as historical documents, which are not currently applicable? Yeah, I don't know. I'm not 100% sure. I mean, I know what you're talking about. I mean, I kind of do, but I would like to. You'd have to ask me on the side to have a little bit more conversation around this. But I will say this, you know, to the extent that there is guidance out there, or there are Dear Colleague letters out there, I think you should definitely be looking at them and considering what they had to say, particularly if they accompany the current rule or current law, right? Do you have a policy paper that supports bundled services? No, I mean, we haven't written anything that, if that's what you mean, that sort of advocates on behalf of bundled services. If someone would like to hire us to do that, I would be happy to draft something, but that's not something we've done to date. I know that there are folks in the community, I suspect, lobbyists and others that represent higher education and trade associations that represent higher education and bundled services providers that probably have drafted these arguments and thought long and hard about them and the value they bring to institutions and higher education, et cetera, that do serve as a rebuttal to the piece by Mr. Shireman. But I don't have those. I haven't made an effort to collect those, no. Let's see. The lead generation agreements, in my experience, lead generation agreements include a price per lead that is at least indirectly based on the value of the leads, which includes how likely they are to enroll. Oh, interesting. So do we think that's a problem under incentive compensation? Well, I think if you know, would you strike an agreement with the lead generator? You know, there's an understanding based on various criteria, typically, which you may assist them in devising, that certain leads are more likely, to your point, to have merit. You know, in other words, certain individuals, based on their particular circumstances and background, are probably more likely to be interested in and enroll in your program. If you have negotiated different pricing, so individuals who fit in a category that is more likely to enroll or less likely to enroll, I don't think that's a problem. But this is an issue of first impression. Honestly, I've not been asked this before, and I certainly don't have anything from the department to this point. But in my mind, I feel like there would be a distinction between that. I mean, you're still paying them for the information. You may be paying them a little more for the possibility or likelihood that that person is going to be interested in your institution, but that person might decline or choose not to follow up, et cetera, or return your calls, and you don't get paid or not paid. They don't get paid or not paid, I should say, based on whether the individual actually chooses to enroll or completes the program, et cetera. And that's what the regulatory language gets at, right? So I certainly don't think that I have seen. I will say a couple of things. I mean, one is there is some litigation out there. I mean, we try to keep current on the litigation around incentive comp, and we've reviewed it. But, you know, if somebody came to me with a specific question like this, a client of mine, I mean, I would want to double check some of that litigation. I'm not aware in any of the law or guidance from the department of any place where they really get at this that I can recall. I mean, there's a lot of preamble and commentary out there over the years, but I don't recall it. It's just such a nuance. I don't think they've gotten to it. I don't know that it's come up in any litigation, but, you know, you should check with your attorney if this is something you're concerned about, and maybe they can do a little research for you and run it to ground. Just be absolutely sure. But my first blush answer is I do think there is a distinction between what you're describing here and what the regulation is contemplating, where, you know, the lead provider only gets paid if the individual actually enrolls, which is success in, you know, sort of success in recruiting and enrollment. It's an interesting question, though, and I don't want to be too cavalier about it, which brings me to another really important point. I tend to be a pretty business-friendly attorney, meaning I try very hard not to be overly conservative. I know we attorneys have, you know, we're often rightly labeled as risk adverse, right? Our job is to manage risk, and we are adverse to it. But incentive comp is not an area where I think institutions should be cavalier. I would always counsel, and I do always counsel my clients, that particularly in this area, it pays to be conservative. So again, if you got a concern here, don't just do it because the guy on the webinar said at first blush he thought it might not be a problem. Run it to ground. Let's see, can you circle back to B2B restrictions? I realize the safe harbor is gone, but what now? Well, a lot of institutions still, you know, have individuals who go out and work on business-to-business arrangements. And I will also note in the commentary to the 2010 rule, the department acknowledged that there could be business-to-business type arrangements, and meaning there could be, you know, compensation arrangements with those who develop business-to-business contracts that would not violate incentive comp. Unfortunately, the department doesn't go into great detail there. They just sort of leave it open and say, you're just going to have to decide for yourself. So my advice would be, if you've got concerns, if you are compensating, if you have someone whose job is to develop business-to-business relationships, and you are compensating them based on the number of those that they develop or how much revenue is generated under those contracts, you need to be thoughtful about incentive comp. You really do. I mean, you may decide that you're comfortable with that arrangement, but it's not a slam dunk, right? If the gift card lunch is under $25 per person, is that considered an incentive comp, or does the 25 limit not even matter? So the 25 limit doesn't exist anymore, right? That was from the 1994 regulation. 2002 upped it in the safe harbor to $100, and then that safe harbor was stripped off the books. Now the standard is anything of value. So if you're taking them to lunch, if you're giving them a $20, $25, gift card, anything like that. If we're talking about something that we're giving to admissions personnel or recruiting personnel that ostensibly is for their success in recruiting activities, covered recruiting activities, it cannot be something of value. And that's the standard, something of value. There is no carve-out anymore for de minimis or token gifts to employees. Now, if we're talking about token gifts to non-employees, like alumni or students who offer referrals, right? This was the last part of the presentation that I covered. And the 2010 administration, the Obama administration, did not like that. Remember, they were very specific about that in the commentary. And they eliminated that safe harbor for token gifts to non-employees. But they also, paradoxically, revised the law to limit the application to payments to persons that are employees. But my point was, I think that was a mistake. And I think that the folks at the department now think like the folks who were there in 2010, and that there may be some attempt to remedy that error, right? What I think they would view as an error. So I would be careful about those referral programs, and I certainly would keep a lookout for any new guidance or anything along those lines that might impact referral programs for alumni and students. Gift cards to students for completion of student satisfaction surveys, okay? Yeah, I think so, right? So here, students aren't individuals engaged in covered recruiting activities or the awarding of financial aid. They aren't employees, and we're not giving them this something of value based on their success in engaging in covered recruiting activities or the awarding of financial aid, because again, they're not involved in either. By the way, this is a great point. For me, the two-part test that does work, that I often apply, the first thing I always ask when people say, can I compensate individuals based on X, Y, or Z? The first question is, are those individuals engaged in covered activities, right? So if I've got any employee or any individual, if they're not engaged in covered recruiting activities or the awarding of financial aid, incentive comp should not come into the picture, right? So it's the issue isn't with the gift card, and I actually think the department's interesting. Some of their guidance and they sort of get off on payments and whether something constitutes a prohibited payment or not. But for me, the starting point is the person I'm paying engaged in a covered activity? And if they're not, that's the end of the conversation, right? If they are engaged in a covered activity, then the question becomes, okay, then am I paying them for success in that activity, right? Or am I giving them something of value for success in that activity? You sort of have to go to that second level of analysis. But here, I think if you are rewarding students for completing surveys, at least that, I don't know if you have a state law or a creditor provision, something else that might get at that, but I don't think the federal prohibition on incentive compensation that we're talking about here would apply to that scenario. Full campus celebrations that are not exclusive to admissions personnel, but provided for all employees. I think that's typically okay. If you are, so the idea, I think the question here is, what if, and let me put it this way. I'll offer a slightly different hypothetical. But let's say the school has had a great half a year, quarter, or whatever, right? And there have been a lot of folks have been admitted, but your retention numbers are up, completion rates are up. Yeah, maybe it's just been great for a lot of different reasons. And you decide to take all of your staff to lunch, or to host a dinner for everyone, right? Or a luncheon for everyone, not just your admissions and financial aid personnel, but for everyone. I think that ought to be okay, right? Because the argument is, I'm not providing this something of value to these individuals based on their success in carrying out their activities. We're providing this something of value to everyone. right, at the entire all our staff and faculty. And the reason is, because we've had a good year, or we're all back, for the first time in person after the pandemic, or, whatever. But you have to be careful. Sometimes, you might say, okay, and I'll just give another hypothetical. Let's say you say, yeah, I'm going to have a luncheon for everyone, and I'm going to have it Saturday morning or Saturday afternoon, I guess, if it's a lunch. But it just so happens that the only people who are scheduled to come in to your school Saturday afternoon are your admissions and recruiting team and one faculty member. Well, this is different, right? And then it sounds, even if you intended it to really be for everyone, if it disproportionately rewards the folks who are engaged in covered activities, I think you need to be careful, right? Let's see. Celebrating enrollments, dangerous in general. Well, I think that when you're talking, celebrating is one thing, but if it involves giving the folks who are engaged in covered activities some sort of thing of value, I think you have to be careful. How do you square the incentive compensation provisions in some schools that are providing cash incentives because a new student is fully vaccinated? Well, I think there are a lot of interesting questions around. I'm not sure I understand the question. If you're talking about a new student, I guess the question here is the cash incentive going to recruiters, and are people engaged in covered activities, and are they getting that cash incentive because they recruited a student who's fully vaccinated? I'm sorry. I know who asked this question. I apologize. I just don't quite follow the question, and it is an interesting question. If you want to, I'd be delighted to circle up after, but I'll just say this. If we're talking about compensating or providing some sort of additional amount or reward to individuals who are engaged in covered recruiting activities, first of all, I think that's always something you have to be very thoughtful about. Now, it sounds like here the argument is that reward is being given to the individuals, the employees engaged in their covered activities, not because of their success in recruiting the individual, but because of their success in recruiting a specific kind of individual, if I'm understanding this correctly. I still think that's something that those schools should be pretty thoughtful about and talk with their counsel about. Honestly, I'm less concerned about incentive comp, although that may be a problem. I'm more concerned about some sort of constructive discrimination, right? If you've got students in certain socioeconomic classes who are more able to obtain vaccines, just as a practical matter, are more likely to get them, with the result that you are providing bonuses to your staff for recruiting individuals who typically fall outside of protected classes, I think you could have a constructive discrimination issue. I got to tell you, I'd be real careful about it. I'm shooting from the hip here. I should probably stop. My loss prevention counsel isn't going to like that I'm trying so much to answer all these questions, but I would be real careful about the concept, and I would check with your legal counsel. I think it's something to be thoughtful about. I'll just put it that way. Is meeting required recruitment goals to maintain employment considered incentive compensation? Okay. So here we're talking about, this is a great question, and what we're really talking about here is not goals. We're talking about baselines. And these are two very different things. So the question is, let's say I'm an institution, and I don't say you have to enroll 40 students to get a bonus a month or whatever. I'll just make that up. But instead I say, we expect our admissions representatives to enroll at least 20 students a year, a year. And if they don't, they could lose their job because that's our baseline. And what's interesting is the person who asked this question says, is meeting required recruitment goals? And I'm going to first, I want to be very clear. I think that is problematic, the way the question is asked. And it is exactly the kind of thing I run into all the time with schools and clients. Because if it is a baseline, it's not a goal, right? You don't tell people your goal is to show up every day to work on a timely manner. Your goal is to make sure you don't get in fights at work. Your goal is not to discriminate against anyone at work. You know, those are baseline standards we expect people to adhere to, like in your code of conduct. These are the things you have to do if you want to stay employed here. And if you're going to use a baseline, what I'll call an activities standard or baseline, and make that part of, you know, the baseline requirements for your recruiting, you know, your individuals who engage in these activities to stay employed, then those things shouldn't be goals. They should be baselines. In other words, you don't want to say like, you know, every year, let's say our enrollment professionals on average enroll about 20 students a year. So we're going to say the baseline is 20. Well, that doesn't make sense, because if that's an average, that means half of your personnel don't meet that standard, right? The baseline standard should be a baseline. Again, it's akin to you're supposed to show up on time every day. You're supposed to know the name of the school and our basic policies. You're supposed to be, you know, we've got a dress code. We have codes of conduct for how you treat other people. You know, so if you're going to use a baseline, you need to think of it that way, not like a target or a goal. Now this, of course, I'm burying the lead. The bigger question here is, well, can you even do that? Right? I mean, you know, we know you can't reward people. You can't give them something of value for hitting a target. But Aaron, are you telling us that we potentially could, you know, take action against them, disciplinary action, or even fire them, right? Or they could, or adjust their salary down, right? If they are failing to meet these baselines. Not clear. It's not clear in the law, but what I can tell you is, there has been discussion around that. I believe there's been litigation on this point in the past. I've talked with a lot of clients over the years. I'm not aware of the department ever taking the position that the incentive compensation rule prohibits institutions from setting a baseline and from taking some sort of performance improvement or other disciplinary measure if someone is failing to meet a minimum standard, right? A minimum standard. Because what the law prohibits is paying someone or providing someone something of value, right? And I think that there's a recognized distinction between that and someone potentially losing their job or losing income because they fail to meet a minimum standard, right? But I will tell you this: it's certainly not clear in the law. I mean, it's not addressed in the law, and to my knowledge, I don't believe it's addressed in the 2011 guidance either. Let's see. What if you have an intercord meeting and you provide lunch? Well, again, I think if you have a meeting and you just provide lunch, let me draw a distinction here. I mean, if you're providing lunch or dinner or anything as a reward for a great quarter, however you want to talk about it, that's different because you're giving them something of value, a covered employee or to employees engaged in covered activities, and it's, you know, a reward. On the other hand, if every quarter you meet with your institution's staff, admissions staff, recruiting staff, financial aid staff, and it is your typical practice, whether they have a great quarter or a terrible quarter without regard to performance, to always have lunch during that lunch meeting, I don't think that's a problem. Because the argument there would be, well, this isn't a reward for anything. It's the fact that we provide lunch at our lunch meetings is totally unrelated to prior quarter performance. Now, if you only provide lunch when you've had a great quarter, that's different. You know, but it doesn't sound like that's the question. Christmas parties that include all employees, and there is a name drawing and a giveaway. You know, again, I think if you have a celebratory event and it is unrelated to, first of all, everyone's invited, and it's not somehow structured in a way that only covered personnel or personnel engaged in covered activities are invited or practically show up. But, you know, if it's really for everyone and everyone can be there and you have a diversity or assortment of people who attend, and as part of that event, you know, holiday event or celebration, anniversary for the institution, whatever, you have giveaways or things like that. I mean, again, the argument would be, and it seems like in this scenario a good argument, the position would be that is totally unrelated to, it's not specific to those employees engaged in covered activities, and it's totally unrelated to their performance, right? It is related to the celebration, and everyone can attend, and everyone's eligible, et cetera. Okay, I had some follow-up to the prior question about, okay, so we're talking about, so this is a question about students, new students who've been vaccinated and providing a cash bonus to students who have been vaccinated, so not to the employees. Well, I don't think, you know, first blush here, shooting from the hip, which again, I'm sure my loss prevention counsel, this kind of thing keeps them up at night. But first of all, the current rule, I mean, I don't like hanging my hat on this too much, but it does restrict the definition of persons to employees. And students aren't employees. So this is why if we're going to, you know, to the extent you can get comfortable with token gifts or anything along those lines, you would be able to do that at all. But here, not only are we talking, if you're talking about, we've got students who are coming in and they're new students and we're giving them some sort of bonus because they've been vaccinated. We're not only are we not compensating an employee, but we're not compensating any person based on success in recruiting. We're compensating a person, in this case a student, based on a totally unrelated criteria. So, you know, I mentioned earlier, my sort of two-part test always starts with, is the person I'm compensating engaged in our covered activities? Because what I'm prohibited from doing is rewarding them based on their success in those covered activities. And my argument would be the student here is not engaged in a covered activity. Getting a vaccine is not a covered activity. It's not a recruiting activity. It's not a, it's, if I'm understanding the question right, it's, you know, and it's not a financial aid, you know, doesn't involve the awarding of financial aid. So I don't immediately see a connection with incentive comp. And maybe, again, I apologize if I'm misunderstanding the question, but I am concerned, even if your policy, again, is written in a way that any student who shows up who's got a vaccine gets the bonus. First of all, anytime it's a cash bonus or something like that, I would make sure it's not too, I mean, the bigger the bonus, the more you're going to attract the attention of regulators, right? The more you get out of anything that could even be fairly characterized as token. But you know, the other thing is, I would just be mindful and careful that it's not structured in any way that could somehow be discriminating against certain classes, of protected classes of individuals. It may not be a problem. Check with your attorney. I may be being overly sensitive or overly thoughtful here, but I'm just mindful that that problem could exist. All right, so I think we're almost at the end here. Thanks everybody for tuning in. A lot of interesting stuff to discuss. Like I said at the beginning, it's a regulatory onion. It seems like a simple concept, but it gets really nuanced as you start to peel back the layers. Hopefully this was helpful. If you think you'd like to hear another presentation on incentive comp sometime, let me know. And if there are particular areas you want me to explore, let me know that. Otherwise, I hope everybody is safe and everybody is well. And tune in next month when we have our presentation on litigation involving student claims. Bye, everybody.